hopefully it's the end of the rainbow.
Rainbow. It's hard to stack.
I was thinking bar and rainbow at the same time.
I'll give her the address. I appreciate it.
Yeah, try to keep our laughter at and on that side.
Hold on? Okay.
Oh, Jesus.
Welcome to the Hillsborough Township Planning Board public meeting of January 15, 2015. Please join me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, the Sunshine Law. Roll call, please.
Robert Wagner.
Here?
Neil Julian.
Here.
Dr. Daniel Morelli.
Here.
Sam Conrad. Michael Merdinger.
Here.
Robert Beeson.
Here.
Sean Matani.
Here.
Vice Chair Steve Cohn.
Here.
Committee Man Fern Dalcourt. Deputy Mayor Greg Burchett.
Here.
Chairman Dr. Stephen Cerrucci.
Here.
Frank will be here in about 10 minutes.
It's okay. It's close enough. Yes.
Do we have her name?
Yes, Mr. Delcor will be here soon.
Susan, nice
He's
to meet you, Susan.
Susan, hi.
Thank you.
Mr. Delcor will be here soon. He's at another meeting right now. First item of business, disposition of minutes, the January 8th, 2015 reorganization meeting minutes first.
All members are eligible.
So moved.
Second.
Any discussion? Roll call.
Robert Wagner.
Yes.
Neil Julian.
Yes.
Dr. Daniel Morelli.
Yes.
Michael Merdinger.
Yes.
Robert Beeson.
Yes.
Sean Matani.
Yes.
Vice Chair Steve Cohn.
Yes.
Committee Man Frank Dalcourt.
He's absent.
Deputy Mayor Greg Burchett.
Yes.
Chairman Dr. Stephen Cerrucci.
Yes. Next up, the minutes of the regular meeting of January 8th, 2015.
Same.
So moved. Second.
Any discussion? Roll call?
Robert Wagner.
Yes.
Neil Julian.
Yes.
Dr. Daniel Morelli.
Yes.
Michael Merdinger.
Yes.
Robert Beeson.
Yes.
Sean Matani.
Yes.
Vice Chair Stephen Cohn.
Yes.
Deputy Mayor Greg Burchett.
Yes.
Chairman Dr. Stephen Cerrucci.
Yes. Next up is a resolution. This is the resolution to approve the resolution for RB, Reckitt Benckiser Manufacturing, file 14 PB17 MSR.
The eligible members, Mr. Chairman, are Mr. Cohen, Mr. Peason, Mr. Lapani, and Mr. Burchett.
So moved.
Second.
Any discussion? Roll call, please.
Who were the members again?
Mr. Cohen, Mr. Lapani, Mr. Peason, and Mr. Burchett.
Robert Beeson.
Yes.
Sean Matani.
Yes.
Vice Chair Steve Cohn.
Yes.
Deputy Mayor Burchett.
Yes.
Okay.
I think I was also eligible,
Yes,
right?
Neil. You should call Neil, too.
Oh,
He's
sorry
also...
about that. My mistake. Sorry, Mr. Julian.
Yes.
Okay. Next up is an extension for Gibraltar Quarry, KDC Solar. They asked for an extension through the end of the year. I know they're currently at Montgomery for another aspect of their matter. So I guess they have to resolve that first.
So moved.
Second.
Is that a voice vote, Eric, or a roll call?
Roll call.
Okay. Roll call, please.
Robert Wagner.
Yes.
Neil Julian.
Yes.
Dr. Daniel Morelli.
Yes.
Michael Merdinger.
Yes.
Robert Beeson.
Yes.
Sean Matani.
Yep.
Steve Cohn.
Yes.
Deputy Mayor Greg Burchett.
Yes.
Chairman Dr. Stephen Cerrucci.
Yes. Again, I'm going to take the correspondence out of order like I did last time. Glengarry Corporation, which was 14 PB01MR, and we've had some hearings on them. There is a letter in your packet of their withdrawal of the application that's currently filed with the board. They're going to put together a new application and file it with the office in the future. Okay? Is there any business from the floor from items not on the agenda? Because on the agenda is Copart of Connecticut. Seeing none, no consideration of ordinances, so we'll go to the public hearing. Continuation, Copart of Connecticut, amended, 14 PB 15 SR, Block 7301, Lot 1, and Block 71, Lot 101, 2124 Camplain Road and Camplain Sunnymead Road.
Mr. Chairman, before Mr. Liebling starts, just for the record, all members of the board who are currently present, who were not present during some portion of this hearing, have indicated that they are eligible, having reviewed the video and/or heard the tape regarding the application.
Thank you, Mr. Bernstein. Counselor?
Mr. Chairman. Mike.
Yep.
Thank you.
It is the fourth time.
I thought he was calling me Mike.
I call you a lot of things, that's not one of them.
We broke off last month when an issue was raised regarding the lot lines of the lots that are the subject of the application and their respective zoning. That was part of the cross-examination of our engineer following his testimony. In the intervening month, the issue has been addressed and resolved to the satisfaction of the board's staff and professionals. I'm guessing you probably want to hear how that was resolved from them before we
Yes.
proceed with the
Yes, so
Okay.
which one of you wants to speak to, okay, Bill? Thank you.
Thank you, Mr. Chairman. The applicant provided us with a deed, it's dated August 21st, 2007, in which that shows that Lot 21, Block 65, Lot 1, Block 72, and Lot 1, Block 73.01, which were basically consolidated back on August 21st, 2007. That's prior to when the board heard the two previous applications. This one was for the very first application in 2010. The other lot was for, it's basically to the west, was the 2011 application. So the lots were consolidated back then. Apparently, the tax maps hadn't been updated, or the key map that was shown on the present application didn't show that consolidation.
Okay, but the deed is there.
The deed's here, it's been filed, recorded, and basically reading meets and bounds, it described the combination of all three lots.
Okay, that's the official record. There had been along the way another issue raised about zoning, whether all of the property which is displayed there as being owned by Copart and operated by Copart is in the industrial zone, which would be the appropriate zone for the use. Mr. Rydell?
Yes, Dr. Cerisi. I would point to exhibit on the right shown on the side wall, in which an area that is in gray at the rear of the main lot, shown with the highlighter pen, was at one point zoned residential. There was a question raised as to whether that was still residential at the time the application was made to this board. Our research has indicated in the memo that I've presented to the board an indication that Block 65, Lot 21, which is that triangular parcel, has in fact been rezoned from residential to light industrial. And there were three exhibits that I presented with my memo. One is dated October 15, 2010, from then Planning Director Robert Ringelheim, indicating that it was at that point found to be an inconsistency in the maps, and that the zone district, which was declared, found to be residential, was in error. The residential district typically is on the the north side of the rail. This parcel attached to an industrial use should have been zoned industrial, along with the remainder of the lot under the same ownership. So Mr. Ringelheim went on to explain the justification for rezoning this property, whether it was a drafting error or something else, not clear. But in order to set the record straight, Mr. Ringelheim suggested that the rezoning take place. There was an ordinance passed, number 2010-31, regarding Block 65, Lot 21, from residential to light industrial. That was adopted on November 9, 2010, and a map identifying the particular lot in question is the last and third sheet of the exhibits that accompany my memo.
So therefore, as of November 9, 2010, the entirety of the subject property was officially in the I-1 zone.
That is correct.
Okay, and that's certainly prior to this application. So therefore, certainly prior to this application and even prior to previous ones, the zoning was all I-1, and a deed was registered that consolidated the lots. So these issues have now been researched, and all the board members have the reports from Mr. Rydell and Mr. White on the resolution. So that has resolved those questions. Counselor, what else you have?
We're our engineers here to continue cross-examination by the public, and then obviously however the hearing continues, we're here.
Okay. Okay, bring your witness up.
Okay, yeah, he's just here to respond to questions.
Oh, I see.
Yeah.
It wasn't just specifically for you.
That's correct.
It's not just the engineer, also the general manager, right? Okay, got it.
We
Okay,
were,
but if it's-
Mr. Chairman, we were actually in the the examination by the public of the engineer.
So it could be anybody at this point.
The
I'm trying to
applicant's
remember where we
engineer,
were.
that's where we were.
We were with anybody being questioned.
Well, no,
Okay.
actually the engineer,
Just the engineer?
just the engineer.
Well, then maybe he should sit at the seat then, sir, and let him sit there if it's basically the engineering questions, and then at the end, you'll, I guess,
Okay.
take turns. Very good. So, the public hearing remain open, because we never closed it.
Correct. Just for, we would ask that the applicant place on the record the individual sitting to his left, the public's
Yes,
right.
it's Carl Alfaro of Van Cleef Engineering. He's been qualified and sworn in.
I remain under oath.
Okay,
You're
so,
gonna need the mic.
are there any other questions from the public for the engineer? Yes.
Maria Janusik, 2155 Camplain Road, Hillsborough,
Spell your last name is Janicek, just for the stenographer, because she wasn't here before.
Janucik.
Thank you.
All right, the engineer, so you have all of the records referred to about the blocks and lots that are part of Copart?
That is correct.
Okay, so in 2007, which lots were
I'm going to object
merged?
to this. This has been resolved. He's not going to answer more questions about the lots, the lot lines.
In
Eric,
two-
is
in two-
that,
in 2011,
Why don't we let the witness, pardon me, the member of the public at least ask the question before you object to the
I'll
question?
I'll go along with that.
Let's also let the record reflect that Committeeman Delcor is present.
Go ahead.
All Go ahead, Ms. Janusik. And ask your question before.
In 2007, which blocks and lots were merged to become what's being shown as Block 73.01, Lot 1?
Lot 21 in Block 65, Lot 1 in Block 72, Lots 1 and 2 in Block 73.01.
And what were they zoned in 2007?
I don't have that information in front of me. In 2007, I know definitely that lot 7301 was in the light industrial zone. Also 72, lot 1, and lot 2 in block 72 is also zoned industrial.
Block 73.01, Lot 1, was granted a conditional use as an internet vehicle processing facility, and that ordinance was passed, that conditional use ordinance was passed in 2010. And then the minutes state that that property was rezoned to include the conditional use, which means that it was something prior to becoming the conditional use. So in 2007, how could it be zoned I-1 light industrial?
That's not an answer question for you. I can try to answer that question, or Mr. Rydell can answer it.
Yeah, I would repeat from, at least in the map that you gave me, Bruce, and you gave all of us board members, that the lot, that triangular lot that had probably mistakenly by map been put in the residential zone was block 65, lot 21, correct?
Yes.
And all other lots that comprise this property now had been in the I-1 zone for a while.
That is correct.
Right. So it's only 65, block 65, lot 21, for which the zone designation was formally changed, and what was probably an error in a map was resolved in, was that November 2010?
That is correct.
Right.
I have often seen, Dr. Chairman, I have often seen...
That's according to your report.
Yes.
Okay.
Applications like this where there is clearly a drafting error, I think there was little intent, given that the land use was not residential, that this could be declared zoned residential. That's, it defies logic.
Right, of course. You have anything to add, Counselor, to...
Just to answer her question particularly, the fact that it was that a conditional use was added to that I-1 zone in, I think you said 2010, does not change the fact that it was still zoned I-1 beforehand.
In the minutes, it states it was specifically rezoned to include the conditional use,
That's right.
which means the lot was rezoned so that it can then be the conditional use.
Don't.
Okay. Okay. Now, as far as block 65, lot 21, that was an ordinance was passed to to amend the zone from residential to I-1. I gave a Government Records, Open Public Records Act request to the custodian of records, Township Clerk Pamela Borek, and asking for when it was filed with the Somerset County Planning Board and the date of filing. And the document that I received shows a lot of empty spaces here for the public hearing notice, for the notice sent by certified mail or personal service, notice postmarked, proposed ordinance enclosed, and then it says here, should any item be missing or incorrect, please contact our office as soon as possible. Thank you, Administrative Assistant, with no name as to who to contact, but this is what I received. Now, I also have the property record card obtained from the Hillsborough Township Tax Assessor's Office for Block 65, Lot 21, and the zone there is shown RA, residential agriculture, and it states that it's updated on 8/6/13. So how was this zone changed in 2010?
Is that a question for the engineer?
You're asking a question.
Mr. Cohen?
No, I asked her, I just say, try to help her. Who are you addressing your question to?
The question at this time
Whoever
is to the...
is
is to-
responsible for the documents that are being presented here.
Ms. Janasek, as you're well aware, we're in the public portion of the meeting in which there are questions of the applicant's engineer. If the applicant's engineer can answer that question, he can answer it. If he can't answer it, he won't.
I can't answer that question.
How did this get so far before the planning board and no one knows this? There've
I'm
been
not
a-
sure, just
No,
just so we're clear, I just
am.
want to, let me
yeah.
just make a, I'm not, I understand your various points individually. What I don't follow is where you're trying to go with it. And if, maybe if you could shed some light on what your end game is here, because frankly, all you're doing is spouting individual facts that we can or can't verify and trying to come to some conclusion. I'm trying to understand where you're trying to go with this, because
Before she answers that, there is one thing I want to address. She continues again and again to refer to documents she got from the tax assessor's office. Those are not official documents that we deal with here.
Agree.
Okay, so every time she refers to something from the tax assessor's office, it's baloney,
Well-
because that's not what we're dealing with. The tax assessor's office gets around to changing its maps later than the actual legal process by which things like zoning and property lines
Are
are changed.
recorded, correct.
So you can show as many tax assessors' maps as you like, where there's a delay or in them being updated, and it doesn't matter at all legally to the proceedings here. So
But,
you just keep wasting
so-
everybody's time by referring to tax assessor department documents.
So my question, so if you bear with me a sec, what I'm trying to understand is there a point to where you're trying to get to? Because the zone was changed. We've established that. There's approvals. There's a document stream here that shows that. What happens in the tax assessor's office is a different process, as the chairman just noted. So is there an end game you're trying to get to? And maybe if we jump to that, it might be easier for us to answer whatever it is you're trying to get to, because frankly, I don't follow where you're going.
Okay. What I'm saying is that what is being presented, the notice that I received said that I can go to the planning board and I can get all relevant records. In 2013, I asked for the map showing what properties were merged. I got the page 16 tax map. I brought that. I was told, oh, no, that's not the map. This year, or the end of last year, I gave that same question. I got the same map with an answer that this doesn't reflect the merged lots. Well, where are those records? I'm a property owner affected by what's going on.
We
And I'm
already
asking for
explained today, but
questions.
you see, your ears are closed.
No, my
We
ears
already
are not
explained-
closed.
Well, if they were open, you would have
My
heard
ears are not
we would have
closed.
heard what we said previously, which is that it's in a deed. It's a deed, not a map, that tells you whether lots have been merged or not.
Why was that?
So you can get
why
all the
was-
maps you want, but if you don't have the deed, you don't have the information.
Why was that not available as far as relevant records
Dr.
at the planning office?
Excuse me, Dr. Cerisi, tax maps are not updated every year. That is a very expensive process, it is a very time-consuming process. Updates to the tax maps for a municipality must be approved by the state through the Treasury Department. It can take upwards of a year for those to occur. We can't speak because I have no personal knowledge as to when we've asked our consultant, who is not represented here tonight, it's a different company, to update the tax maps.
Right, so for the taxpayers, updating tax maps continuously would be expensive and actually increasing the taxes. So you don't do it. The question, I think, though, was So when an information request is put into you for this application, why didn't you supply the deed that showed the merger of the lots?
We do not have within our office the deeds.
Right, so
They are
what-
contained at the county level.
At the county?
Yes.
So in other words, you can only provide from your office that which is in your office.
That is
Deeds
correct.
are with the county.
Yes,
So one would have to ask the county for a copy of a deed.
yes.
Okay.
Dr.
Okay.
Tracy, just to cloud things up even more, when they merged the lots, they maintained one of the block and lot numbers and did not change it to a point number from, say, 1.01. They did not create. So when you would look at the tax maps, you would see
It was unchanged.
that it appeared that it's on the tax map, so, and they asked for a certain lot, it's on there, so it should have been changed on not only the deed, but then you would have seen that the deed didn't correspond to the tax maps, and there would have been an understanding that the update hadn't been done yet.
Yes, but all deeds are recorded with the county.
Correct.
So that's where you'd have to find deeds. That's with the county, not with the township.
Where are the official records for individual properties within Hillsborough?
Somerset County.
Those are the deeds, and they're in Somerset
Not the
County.
deeds, the property record card.
The property record card, that's my turn. The property record card is information produced by the tax assessor's office regarding the information it has regarding the owners of record that they have been made aware of, the sketch relative to the valuation or what is supposed to be on the lot, and a valuation placed on it for purposes of taxation, which may or may not be totally accurate depending on what information they have. But the property record card does not indicate in and of itself deed information. It merely indicates information that the tax assessor has relative to valuation.
Does that record also show the zone that the property's in?
It may or may not, and the fact that let's put it this way, if the card says it's zoned highway commercial and it's not in a highway commercial zone, that doesn't make the zoning inappropriate simply because there may be a mistake on the property record
Yeah,
card.
it just makes the card wrong.
It's not an official record.
It's
I
not an
think is the
official
point.
record, certainly of the zoning, and if the zoning on the card is incorrect, it just makes the card wrong. It doesn't
Well, then
change the zoning.
where is the official record in the township on the
As-
zone of properties?
As indicated, it's the recorded deeds are at the county.
Well, the
deed,
zone is the
deeds.
ordinances.
I'm asking for the zone.
The ordinances create the zone.
So why couldn't the county give information? This is something I received from the custodian of records of Hillsborough, and there was no information on the document that I received.
That's correct.
In response.
If the county had chosen not to advise or provide to the township the deed, for example, it cannot be in the possession of the custodian of records because the township doesn't have it.
I didn't ask for the deed. I asked for the information regarding the ordinance and the filing of that ordinance
Did you
with
a-
the
did-
Somerset County Planning Board.
Did you ask for the specific ordinance?
Yes, I did.
And
Yes, I did.
Here's the problem, Ms. Janasek. Right now, everybody is taking your statements on face value. There is nothing before the board regarding the Oprah request you made, regarding the...
I have a copy here that I can
Mrs. Janasek,
present.
can I finish, please?
Go ahead.
Nothing that indicates what your response from Mrs. Borick was, nor when you got or didn't get what you were looking for to get what you did beyond that. The planning board is not involved in the creation of, providing of, or adjudication of public records under the Open Public Records Act. That's either the courts or the Government Records Council. If you were not satisfied with the documents you get, this board can't get you any better documents than you got from the clerk's office. So to ask this board to somehow tell you why you didn't get a specific document you may or may not have been entitled to is not an answer that anybody up on that dais can tell you, including 2 of the 5 members of the governing body, because it's not in their purview. The custodian of records in the township of Hillsborough is the township clerk. She's responsible for the records, and if you're not satisfied with the records you got from her, the person to deal with is her, not this board.
It isn't that I'm not satisfied with it. I'm just saying that no information was provided.
Well,
Now,
the
okay,
last
all right, I'm
last
gonna
time I
skip
looked, that was lack
I'm
of
gonna skip that.
satisfaction.
But when I was here in November, I presented this, which was this map, which was given in as exhibit.
Right.
Showing Block 65, Lot 21 is zoned residential. This is the site plan prepared by your professionals over here. This should be up-to-date information. Why is it showing, so this is showing residential, and
think-
everything else is showing residential.
I think the applicant testified that that was a mistake on their part when they created that map. Right, Mr. O'Farrell?
That is correct. It is an outdated map, and it was a mistake on the plan.
But it's interesting that other records also corroborate that this is zoned residential.
Here's the ultimate problem, and I'm Mrs. Janicek, and I'm sort of piggybacking on Mr. Delcour's comment. If the property was incorrectly or correctly zoned, I'm talking Block 65, Lot 21 as residential, back in 2007, and it was corrected by a correcting ordinance in 2010, and it is today, January 15, 2015, what does that have to do with this application? Because any issue you have regarding the appropriate is well out of time back for 07 or 10. So for the purposes of this application before this board, the fact that a property may have been improperly designated in a zone 5, 6, 7, 8 years ago has no impact on this application, since there doesn't seem to be a dispute as to the zoning for this property.
What I'm finding is that there's a lot of verbal information, but it's not being supported by written information. Block 73.01, Lot 1.
No,
Property record card shows...
Let Eric do this. 'cause
Actually, Mrs. Janicek, just the opposite.
it's just the opposite.
The written information clearly supports the zoning.
I haven't seen it.
It's your verbal filibustering that's
I have
completely
not.
inaccurate.
I have not seen it. Someone
right
stands
here.
up and says, "Look,
right
yeah,
here.
right here." Well, I haven't seen
right
it.
here.
I haven't had time to look at this. I haven't. Had
It doesn't
time.
make it any less
I
true.
haven't had time.
Whether you had time to look at it or not, when
Yes.
you've had plenty of time
Yes.
to find it,
Yes.
it doesn't
No,
make it
this
any
was
less
not present-
true,
this was
any
not-
less
this was
fact,
not
or any
given to
less,
me.
or any less the evidence that we have to vote on.
This affects my property. I'm a property.
Take
I
5 minutes
please,
to go read that.
please, no. I want to say.
And come back.
I want to say. I'm a property owner affected by Copart, negatively affected, negatively affected by
So,
Copart.
Ms. Jansen-
I was not given, please, I listen to everyone, please listen to me.
No, we have
2000
listened to you and listened to you and
2011,
listened to you and listened
You
to
had
you.
you let things go over here.
Don't worry about it.
Where I was
videotape.
legally supposed to be notified. If there was something that I wanted to dispute or discuss or whatever, I should have had the opportunity to speak to an attorney and to defend my property, which I wasn't allowed to do in 2011. Now I come here and you say, oh, here, we have this. In 2013, I asked about
At what
about the
time- at what point
acreage
does
of
this
Block
become out of order that it can be
73.01. I was told
gavelled
it's
and
15
removed?
point something acres. When I asked for the map, here it is, but no one gave it to me, and that was in 2013. And here we are, 2015, and I still don't have that acreage, how that came about.
Okay. And let's assume, for the sake of this discussion, everything you said is true,
Yes.
that you weren't provided any of that. What does that have to do with the application before this board? The board is hearing an application regarding an expanded use of the current property in an appropriate zone which is allowed for the use in which it exists. As far as consulting an attorney, ma'am, this application has been going on for 6 months. This is the 4th hearing. You had ample opportunity to consult with counsel. I'm not going to respond whether you did or you didn't, but the fact of the matter remains is at this point, the continuing discussion of whether or not a triangular piece of property in a zone that is no longer in that zone and hasn't been for over 4.5 years has anything to do with this application. And I would indicate to the chair at this point that any further discussion about what zoning may or may not have existed 4.5 years ago as it relates to this application is out of order.
how is it that trucks are allowed to go into one lot, 73.01, traverse over someone else's property, and go into another lot that has no access onto any road? A property that has wetlands that violates an ordinance protecting wetlands.
Mrs. Janasek, let's stop one part. I believe you have been sworn in, so for the purposes of, and I put this in quotes, testimony, close quote, you have sworn to whatever you're saying, but the fact is there's nothing before the board regarding any of that. So to the extent you want to know how the applicant traverses, I think Mr. Liebling, on behalf of the applicant, can indicate how his client traverses from one side of the property to the other.
Well, I just have to correct you that it's not someone else's property. It's under single ownership. And they drive from one side of the property to the other side of the property.
But there's property in between lot 73.01, lot 1, and block 71, lot 1.01. There's property in between.
We'll let the engineer explain it again.
The lots are connected right at this point up top here. So what they do is they drive from 7301 up along over here along this little triangle, and they go into lot 1.0171. There's no, the lots are interconnected.
And we've agreed to consolidate them as a single lot, which we could not do if someone else's property was separating them.
Where are the records showing when they were merged? And who was notified? What property owners were notified that these lots were, blocks and lots were merged?
No.
They haven't been merged yet. Mr. Rydell asked that we do that in connection with this application, and we agreed to.
The fact is, the lots have not been merged. The ownership is continuous. And the fact is, there is no requirement for merging of lots to be given to the public. You get notice for an application before a board. You don't get notice every time something happens related to the property.
When someone is doing something different to their property, surrounding property owners don't have to be notified?
If it is not before the planning or zoning board, there is no requirement of the individual to notice people within 200 feet. There's a specific requirement under 4055D12 as to what characterizes notice. And if the applicant has no pending application before a land use board, they are not required to give notice to the surrounding property owners relative to acquisition of property or anything else of that matter.
So when someone has 4 separate lots, they can just themselves merge those lots? Or do they have to come before the board?
No, they can actually ask for that either with the tax assessor's office, or they simply have the lots in question. There's continuous ownership.
Merged?
Merged is for purposes of tax purposes more than anything else.
Well, I'm told here that these blocks and lots were merged. So that had to come before the board.
No, it
So if
doesn't.
that came before the board, then people had to be
No,
notified.
No.
You
you're wrong
really
again.
listen to what they tell you, because
can
it just specifically said, as part of this application, they've been asked to do that, and they had not done it yet.
I'm
He
talking
said
about-
it at least 4 times.
I'm talking about the other ones.
The other ones weren't part of an application when they were merged in 2007, so they didn't have to come before the public.
They were, I'm saying, the property owner could just merge them himself?
The council has already told that to you a couple of times, and you still do not listen or understand. No, they don't.
Mr. Chairman, isn't she out of order? She hasn't asked a question regarding that.
No,
This is
it's,
not a public portion of the meeting.
it is.
No, it's not a public portion of the meeting. It's the questioning of.
Of the engineer, right. Well, something
And
about
we're out of
how,
order right now because this is not a
Right.
question, and this is not a parade of the application where you just can discuss.
yeah,
any-
so none of that is
Any
relevant.
of these questions that you have to pose right now need to be posed to the engineer.
I just want to
or-
make a statement.
You
Not
can
that-
do
I
can
want
do
to
that
make a
at the end.
statement that
There'll be time for that.
the records
Mrs.
that, the
Zanisek, go
minutes,
back and read that
records,
and then come back
all
at
of
the
there is,
public
there is a
portion.
lot of
You're out of
false
order. Steve,
information.
please.
There's a lot of false information
you like to
in the
do? Want to get
minutes,
the police
in the
here and have her
resolutions.
removed?
Yeah, maybe we should call
I would request that, because I'm gonna make a citizen's complaint. I would request
I want you
it. I
to
would
take a
request
seat,
that.
read the
I would
material,
request,
and come back
when it was
for the
mentioned to
public
call a
portion
police
where you
officer,
can
I
say
would
what you
request
wanna
that,
say.
because there is fraudulent information being provided to me as a property owner, to other property owners here, and to whoever is here as a member of the public.
Well, you can
Fraudulent
make-
information
you
is
can make
being
all the
provided,
slanderous
and
claims
this
you
board,
want. They
this
mean
board that has a
nothing. They
fiduciary
mean nothing.
obligation to the taxpayers and property owners of Hillsborough is aiding and abetting in the violation
the
of
police.
ordinances.
No.
Also in the violation of federal, state, and local environmental laws and other laws.
If that was the case, please bring counsel.
I am asking.
Go to court and sue.
Please.
Hire a lawyer. and
We've
sue.
given you more
No.
than ample time. I've had enough.
The government has lawyers. The government has lawyers. This is a violation of my rights. This is fraudulent information. I'm reading minutes. I'm reading records. This is all a bunch of BS. And you're going to stand up and say, here is the record. How come I didn't see it? How come I didn't see it 2 years ago?
Could you just go back and read that, please?
That won't make any difference.
Well, she reads it, maybe she makes sense of it and she'll understand.
I
it.
doubt that very much.
Well,
So, any other questions for the engineer? Okay, seeing none? Counsel?
At this point, we've completed our application, and
now it's the board's turn to ask some questions of you.
Yeah, now, if there's
Now
any
it's our
residual
turn, right?
questions for any of the witnesses. or-
absolutely.
Yeah.
Well, can we
Go
go
ahead.
through?
Yes, go
Eric,
ahead.
is there any possibility we can go through the laundry list of items that we're asking them to do as part of the resolution? So we can one by one hear them say it again? Something about the lock or the self-locking, the timing, all
Here's
that
the,
stuff.
here's the problem,
I
Mr.
forgot
Carter.
everything.
I don't have all the transcripts. I usually don't get them
Right, I
until the
understand.
matter is completed.
Maybe the attorney for the record could please state
I can
what
t-
it is we agreed to.
I can tell you what
Please
my
do that,
my notes.
point by point, slowly, so we can
Okay.
all understand and acknowledge it one way or another.
Okay. Okay, we are seeking to extend the hours for when the business is open from Monday through Saturday, 8 to 5. Inventory can be delivered Monday through Friday, 8 a.m. to 11 p.m., and Saturday from 8 a.m. to 3 p.m. Those are the drop-off hours. Mr. Bernstein, I assume if their resolution is drafted, you're not going to rely on this. I'm trying to just.
No, I'm going to, for the purposes of the record, any approval will be based on all the conditions of which the applicant
Okay,
has
I'm trying to
indicated on
just
the
be
record.
somewhat
I
telegraphic
understand
here.
what,
This is just for to
well,
bring it to
may-
the board
may-
for an
may-
understanding when making a motion.
Mr. Chairman,
what we're-
maybe to
yeah.
assist Mr. Cohen and Mr.
Uh-huh.
Liebling, I'm reading from what has been marked as A1,
Uh-huh.
which is actually Mr. Liebling's letter of December 8th.
That's what I'm reading from.
Uh-huh.
But you want me to read, or you
I'll
want
go
to read?
on. Allowing the applicant's employees to be present outside of business hours and drop-off hours. Following a declared state of emergency in New Jersey, allow full operations on Sunday from 8 a.m. to 5 p.m., provided that prior to a Sunday opening, incoming assignments, i.e. drop-offs, have exceeded 120 damaged vehicles per day for 5 consecutive days. In connection with a given state of emergency, more than four Sunday openings shall not be permitted. The applicant is proposing to undertake the following mitigating measures in connection with the modification of operating hours. With respect to the closing of business hours, gates will be closed halfway at
All right,
5.
we changed that. We agreed to, gates will close at 5 p.m.
Gates will be closed at 5 p.m. to indicate closure.
Period.
Period. Gates will be closed after the
That's
last.
gone,
Gone.
yes.
Signage on the exterior of the office will show business hours as Monday through Friday, 8 a.m. to 5 p.m. For delivery of inventory occurring during evening hours, a time-locked gate will be installed that cannot be opened by subhaulers after 11 p.m. Is that correct?
Yes.
No more than 45 trucks per week. No more than 100 damaged vehicle, total of 100 damaged vehicles per week. The
evening hours, this is what we're talking
We're
about.
talking about evening hours. Time
During
lock,
evening hours, yeah, it's
Right.
number 2. For
time
delivery.
lock gate will lock at 5 PM if the amounts in either the 45 trucks per week or no more than 100 damaged vehicles per week has been reached earlier in the week. The maximum size truck to drop off during evening hours will be a 4-car carrier. Drop off in evening hours, i.e. vehicle staging area, will be monitored by existing video. The township, I think we changed this from may to will review video and drop-off logs, I think was on a weekly basis, to confirm hours and number of trucks/damaged vehicles. And a certification of counts will be provided by the applicant to the township on a monthly basis. Subhaulers whom the applicant is in constant contact will be advised not to attempt delivery of vehicles in evening hours if maximum amounts have been reached earlier in the week, since the gate will be time locked. I also believe, though it's not mentioned here, Mr. Liebling, that you would agree to provide your client would agree to provide an ongoing list of haulers and subhaulers.
Yeah, that was after the letter.
So the township would know.
Yep.
If a number of deliveries are expected in evening hours of a given day that would result in the maximum amounts being exceeded that evening, subhaulers will be contacted during the day so that the maximum amounts are not exceeded. You might want to bring your general manager back up before this is over.
Okay.
Subhaulers will be given guidelines with operating restrictions and will be required to acknowledge that repeated failure to comply will result in termination of contract. 3, no operation of equipment in the yard after 6 PM. Only equipment operation will be in the pickup/drop-off area. Applicant to install signage on Camplain Road indicating that parking restrictions are strictly enforced and that the trucks that are parked there will not be serviced at the facility. Just for the record, since it comes up at this moment, and I know there's a gentleman sitting in the audience regarding such, there is a no parking on Camplain Road right now, period. And apparently, it is still coming up that your clients' haulers still do not understand the words no parking. So
Does parking mean stopping to get out
it
and open
means
the gate?
anything.
Well, they have to get out to open the gate.
They're not going out to open the gate, they're parking. They are literally in a fixed position for a period of time longer than it would take to simply get out of the car, open the gate, get back in the truck, and drive through the now open gate.
Did the police go out there, or how do
The
we know?
police, because the police have been out there within the last week. The administrators received phone calls, and so have I, so.
And we certainly encourage that law
So
to be enforced.
irrespective of what happens, post bilingual signs in the office reminding haulers to avoid driving on neighboring property. Require existing trucks to make a right turn only and install signage and striping to that effect.
Exiting.
Exiting that property. Left turns will still be allowed for passenger vehicles exiting out of the separate office driveway to the east. Repair damage to lawns, landscaping of neighboring properties resulting from Copart business activities. Install privacy features in the front gate. Replace existing landscaping where required. During the Saturday business hours, no use of motorized equipment excluding dust control within 400 feet, and I thought that was amended.
I don't think
400
so.
feet of the eastern property boundary of the main lot, which is the buffer area. Adopt following best management practices in the buffer area to control fugitive dust. A 500-gallon water trailer with pumper and sprayer. Purchase and installation of a wind meter and anemometer on the roof with the readout wired inside an office garage for easy reading when the wind direction is from the north to northeast and wind speed is above 8 miles an hour. The threshold for lifting and carrying fine particulates from the soil. The buffer area, if dry, will be sprayed, and posting a 5-mile-per-hour signage inside the facility.
We also agreed that we would do anything that required written activities, for lack of a better term, to be done within 30 days, that any physical improvements would be done within 90 days of an approval, and those would both be conditions of the new hours actually being permitted.
And whatever other requests were made by the various professionals, Mr. White, Mr. Rydell, Mr. Winiger,
and whoever else is, and the Environmental Commission. Mr. Cohen,
I'm done.
Okay.
I'm done.
Frank, you have something?
Yeah, so, a couple things. I'd like to verify, one, I guess based upon what we just heard, that there will be no deliveries on Sundays. So from Saturday at 11 until Monday at 8, there's nothing?
It's not Saturday at 11.
Saturday at 3 p.m.
Saturday
So
at
3,
3.
sorry.
Barring a state.
No, barring. Yes or no is the answer.
The answer is no, because the state of emergency request permits Sunday activity limited as he.
Barring state of emergency.
Barring state of emergency, your statement's correct.
Correct, okay. I will say, I find it, distasteful is probably not the right word, but difficult to have to inflict that level of scrutiny and criteria against a business to operate normally, but frankly, you've left us no choice, because I have very little in the way of confidence that absent those, there would be a good partner and neighbor, because there's been so much from the residents in the area that we continue to have these issues, and without the monitoring, I don't know where we would be. So what I would say here is I think these conditions have to be here. They will be scrutinized, assuming this gets approved. And I would be prepared to make sure that your client, the employees, the haulers clearly, very clearly understand what's been placed before them. Because I do not want to have to deal with the gentleman in the back there or any of the other residents coming in and saying, I know you put these in place, but there's cars parked every day and we're still getting Sunday deliveries and there's stuff showing up all hours of the night. Won't tolerate it. So I'm on record with that.
Okay. You both heard that loud and clear, I'm sure.
I think actually we'd like the general manager up.
Okay.
Yeah, you're agreeing to it, doesn't matter. Yeah.
Oh, no. Well, it'll be in the resolution, but
Somebody from the company who is willing to go on the record that they understand and comprehend what the committeeman just said, because as the chairman indicated, with all due respect to Mr. Liebling, he has no more authority to bind you than the man in the moon. Does the applicant understand that if this board were to approve this application with some and or all of the conditions requested, that you will abide by whatever conditions are placed into the resolution allowing you to continue to operate?
yes.
Does the company understand that there are consequences, financial and otherwise, available to the township if the applicant fails to comply with not only the current conditions, but any future conditions for operation?
Yes.
And do you have the authority to bind the company?
Clarification?
Your yeses, are they as useful as mine, or
Oh.
are they, can you make those statements on behalf of the applicant, co-part of Connecticut?
Yes.
Thank you.
Chairman, I'd like to
Yes, of course.
tag on to Frank's comments.
Certainly.
Frank mentioned, you have to be a good neighbor. Part of being a good neighbor is listening, too. And what people said here is very important. Every one of the board members have driven by your facility hundreds of times. And today, at least 4 or 5 of us have driven by. The gates were still open at 7 o'clock. There's litter all the way past Klein's on your property near the fence. But all the other properties around you clean up that litter. You don't do patrolling. Your property, although you put nice white fence and bushes there, looks terrible right now. I drove by it at 4 o'clock. and your neighbors don't. So that just means, you know, like when I go out to my frontage on the road, if there's a can there, I know you didn't put it there, but you still have to patrol. Along with that is the dust control. Now, the dust control was not mentioned in the punch list, but you mentioned the dust control. You want to reiterate that so we get it on the record, so it's...
I did, Mr.
Oh, you did? I
But
wasn't sure.
let me again, for the purposes of the record, relative to the dust control. Adopt the following best management practices in the buffer area to control, and I love the phrase, fugitive dust. A 500-gallon water trailer with pumper and sprayer. Purchase and installation of a wind meter and anemometer on the roof with the readout wired inside an office/garage for easy reading. When wind direction is from the north to the northeast and wind speed is above 8 miles an hour, threshold for lifting and carrying fine particulates from the soil, the buffer area, if dried, will be sprayed.
Yeah, it's item number 11 on the list.
Correct.
But basically, I want you to focus on doing things that you said you'd do, because we haven't seen it yet. And the last thing is noise. You know, you can't exceed 85 decibels for your own workers, let alone the people that border your property. And we have noise ordinances, we have dust ordinances, we have all these ordinances in the town. There's no parking on Champlain Road. You have to be a good neighbor and a good partner with the township. And that's what we're asking you to do.
I agree with you 100%.
Thank you.
Anyone else from the board? Any questions for any of the witnesses or comments? Okay. So,
Final public.
Public.
Public to the witnesses, open the public to the public.
Public, it's a
it's
continuing
open,
open.
public hearing's open.
Open the public
Right.
comments to the.
So this
application.
is the, at this point, yeah, at this point, it's the last opportunity. You could, if there's a question to ask one of the witnesses, they're here. If there's something else you want to say, now's the time to say it. So, anyone who wants to speak, I'll start on the left. Do you want to say anything? Okay.
Good evening, everyone. Michael Sopko, SOPKO, live at 2127 Champlain Road in Hillsborough. Where do I start?
By raising the microphone up to your mouth, so everybody can hear.
I can do that. Is that better?
Yeah.
Okay, sorry about that.
It's okay.
First, yes, the dust is atrocious. It comes, it goes. There's nothing that I can do about it. I can wash a car in the morning. By lunchtime, I got to wash my cars again. As far as the parking on Champlain Road, I have called the Hillsborough Township Police, and they have told me, they have come out to my house and specifically told me that the cars parked on Champlain Road are legally parked.
Well, funny you should mention that. I will indicate for the record that I have had a conversation with the administrator, who I have been led to believe has had a conversation with the police chief regarding that issue. And that hopefully any, how should I put this, confusion has been resolved.
Thank you. Also, when the tow truck drivers come in after hours, between the 5 and 11 at night, they pull their trucks in, they unload the vehicles. However, they keep their flashing yellow beacons on the entire time, which this time of year, it's dark out, the whole sky is lit up, flashing for 15, 35 minutes at a time, depending on if it's a 1-car carrier or a 4-car carrier. Very annoying to the neighbors. As far as my property...
I'm sorry, one second. Yes, Mr. Bernstein.
Mr. Liebling, is your client willing as a condition of this application to indicate that they will, that their haulers will not use flashing beacon lights? I don't know who they're flashing for.
Once they leave the public roadway?
Once they
I don't
get...
know what the equipment does, if it's automatic, do you know how that
I have
works?
no idea how it operates.
There must be an off switch.
I happen to own a couple of them, so there is an off switch.
There's an off switch. It's just that they can't be bothered. So that should be that needs to be one of your rules of your business, is that those lights are turned off once your haulers leave the main road.
You understand what's being asked?
Yes.
Yeah.
Applicants willing to agree to that as a condition?
Yes.
Thank you. This is your wish list tonight, Mr. Sofko.
Thank you. Also, the property that, at the end of mine, that is getting run over continuously, instead of putting stones so that the operators can continue to run over my property, something more structural that they know when they've hit it. Not so much spikes.
Landmines?
You know, nice guardrail, cement wall. You know, I have a picture of what my front yard looks like. I took it this afternoon.
Now, one thing I would caution you, remember, you know that generally speaking, the public right-of-way of the road extends beyond the road surface and the gutter.
Yes.
So if one was to put a wall, that might be on something that you currently use as your lawn.
That's fine, because a wall that is permanent is easier to fix than my lawn the way it looks now.
Okay.
Mr. Sofko, do you wish to have the board view any pictures? Is that what you're...
Sure, I can give you, I have a picture in my hand that I took this afternoon approximately 4 o'clock.
Why don't you provide it to Mr. Liebling?
Instead of taking the time to show us pictures, how about we just have an agreement?
Well, I think the public is allowed the right to show the picture to the applicant.
Yes.
You know, we're going on the 13th hour of this application, so
Mr. Sopko, what you provided,
patience is
Mr.
very
Lee-
thin.
Yes, I'm well aware the board is all, for the purpose of the record, Mr. Sopko, can you indicate what you provided Mr. Liebling?
That is the end of the property, directly coming out of the, if you were to exit out of Copart's, making a right, that would be directly across the street.
So I need to ask him one
Sure.
couple questions. Okay, so the picture that you, we should mark this.
Well, we're going to mark it P1. You just write on it, P1 today.
Okay.
Thank you.
The road surface that you see here is Camplain Road?
Yes, sir.
Okay. And is this a newly created condition?
That's been happening since, it's an ongoing thing with Copart's, but it has been getting worse since the last meeting in December.
Okay. And this results from a truck doing what?
Several trucks not being able to exit Copart's properly and making too wide of a swing and running over the property.
So they exit Copart and turn left?
They turned right.
This is from a right-hand turn?
Yes, coming out of Copart's and making a right-hand turn.
So they pull out across Camplain Road?
Right.
Drive
Both
over
lanes.
this, and then
Correct.
go back
Yes,
in that okay.
going towards 206, yes.
Is that something that happens?
Yes.
Okay.
You get the mic there.
Yes.
Okay, and we had proposed stones here to keep this from happening.
It won't keep it from happening, it just won't ruin the
Right,
property.
it won't ruin the property. And what's the matter with that solution?
It's not fixing it, they're still gonna run over the property. There's, the stones, how big are these stones? Are they gonna get pushed off? How much landscaping am I gonna have to, with weed control now?
I don't, and I'm just, this is, I guess, just really a discussion point. I don't know that it's right for a business to deal with guardrails, wall maintenance, et cetera, for people driving on parts of the right-of-way that they don't
You're right,
belong
it's
on.
not, but that's assuming you don't ruin it in the first place.
If I recall, Mr. Alfaro testified, correct me if I'm wrong, Mr. Alfaro, that basically he put the turning template on there, and the truck should be able to turn it. So it seems that it's operator error, and that's your subcontractors. And if they can't follow the rules of the road and drive properly, they should be terminated.
That is correct. The turning templates were run, and the trucks can make the movement. I myself actually was thinking about something exactly what you were suggesting, maybe landscape boulders or something of that fact. But the problem is that that portion of the road, or that portion of Mr. Supko's property is located within the right-of-way. To put something of permanent structure so close to the edge of the road might pose a hazard for someone driving.
Yeah, so it's not actually your property. You know, it's like we all know, you know, that there's a piece in the front where we may be mowing and whatnot, which actually isn't ours. It belongs to the town. We just mow it for them, basically, and then use it.
Yes.
So if this is that, in a sense, it's not your property. And then if you do build things like walls and boulders and whatnot, it would be a hazard for someone who, say, on an icy day, slides off the road, and instead of sliding across some glass, whacks into a boulder. So there's a potential safety issue with that.
Chairman, possibly a no parking sign affixed in that area would deter that turn at that area.
Now that's very good, because that wouldn't destroy anyone who slides off the road. They just take out the sign. And on the other hand, would be some discouragement for truck drivers, at least a visual cue.
Oh, you don't want to straight the car out.
You have a problem with that suggestion, Mr. Sopka?
No, I don't have a problem with that suggestion, no.
So probably then we should do the stones, and then in addition, the signage.
Oh, wait a minute, do you have object to having a sign?
I have a sign on the other side of the property that already says no parking.
I know, but
that's not in the turning section,
But
so
in the
you move
turning
over.
zone.
I have no problem with that, no.
I don't have a problem with that either.
That's
I'll
a
put
great
that on the
idea.
list. Does the applicant agree to that? I don't want to hear from you, Mr. Lublin. Sorry.
Wouldn't the homeowner want to relocate the current sign, just so there's not multiple signs in his yard?
That's what we're
That's
proposing.
fine.
Yeah, sure. Yeah, exactly.
Yeah, that's fine.
As
So
long as-
essentially, we're proposing to put the sign in this turn area right here, which is visual from a truck. When you sit up high, you can see it, plus obviously he doesn't want to hit it.
And if Mr. Sopka wants another sign on the other side, the other end of the property saying no parking as well, I'm assuming nobody's going to stop him.
I have no problem with two signs.
But just thinking out loud here, though, is there an ordinance where the sign has to be so far back off the road? When they,
Actually, for no parking, the sign needs to be as close to the road as possible, so that there is no dispute as to what's not to happen.
So we'll let you know
yeah,
where,
I was
where
just
it can go in
concerned.
the.
I was just concerned it'd have to be too far back. where it
Well,
would
we
be
can nail those, the numbers down.
Okay.
That's fine. That's a good
As
idea.
close as possible to the road and as far away from Mr. Sopko's house as possible, within the limits of the law.
Yes.
Anything else, Mr. Sopka?
During normal operation, they have a sign posted right now inside their property, says, "Stop, sound horn, then proceed with caution." So every time a vehicle goes from the front lot to the back lot, there's a horn that goes off. Every time they go from the back lot to the front lot, there's another horn that goes. If this goes through and being allowed to have Saturday hours, now I have more horns and more noise.
It's an interesting one, too. What's with the horn, blowing the horn?
That's a safety concern, because the front end loaders, there's low visibility when they go in and out of the gates. There's limited visibility for people on the ground, so it's a safety concern.
How about some electric eyes with flashing lights instead?
As long as the flashing lights aren't after the sun goes down, then it's the same as the beacons on the tow trucks.
Well, no, it's not continuous.
No.
It would just
Yes.
happen when the gate's opening, see? So instead of being continuous for 35 minutes while the truck's there, it would happen when the...
And it wouldn't traverse the distance anywhere near your home.
Let's just ask the applicant when the honking is occurring.
Yeah.
It's during normal business hours, not these late-night drop-offs.
Right. Actually, when there's a late-night drop-off,
Then I
there
know
shouldn't be
there
anyone
is-
else there, so there's nobody to honk for.
Correct.
Do they honk anyway?
No, he's referring to when you go inside the storage facility, which is not open after hours.
Okay, so that's the 8 to 5, 8 to 3.
Okay, my fault, sorry about that.
No, but the answer is an electric eye or some other form of device other than honking a horn.
I think you're approaching OSHA.
I'm just at,
It's a question. I think the
Is
main
Is
concern.
the applicant willing to allow its engineer to work with the board engineer to try to find a solution other than the honking of horns?
It's something that we can't decide on right now. It has to come from our corporate office. But I don't think it's something that we can do. It's our procedures, it's our safety procedures, it's company-wide. I don't think that's something that we should change.
Well, it's your procedure not unless it's mandated by OSHA. It's something that can be changed.
I think the point was that we at least agree that have the engineers work through a solution.
But Mr. Sacco just said he's okay with it during business hours. It's just after hours that he did it. So now we're continuing.
That's correct, yes.
Okay.
Yes. Fine.
Well, I don't know if he's okay with it. He's learned to live with it, I guess. But during business hours, if that's the only time, it doesn't seem
The only
strange.
reason I think Mr. Sacco is raising the issue, Mr. Liebling, is that your client is now talking about adding one more day to a
right,
week
Saturday.
of,
That's true.
A week of horn
And
honking.
he understands that, and he said okay, so I'm not sure we should be making.
No problem on Saturday?
Being that only for drop-offs, then the back won't be open, so there will be no horn blowing.
Okay.
Okay. The only other issue I have, and it doesn't have to do with what's in front of the board tonight, but we all know that Coparts does not allow the tow truck operators to fix cars. We know this. The problem is the tow truck drivers come to me and ask if they can fix their cars in my property, or they go and try to pick up too many cars from Coparts and they ask if they can leave them in my driveway until they can come back at a later time.
Seriously?
Yes. Yes.
Unbelievable.
This is.
So can I ask you, have you ever shared that with them?
I'm
not trying to put the onus on you, I'm just wondering if they're aware of that issue more.
not with Mr. Hopkins, but with previous managers, and previous managers haven't been as considerate as Mr. Hopkins has.
So that's gonna stop though, right?
Yeah, but
What happened?
that's individuals.
Yeah.
I mean, how can you have a
For the purposes
corporation?
of the record, can you indicate who you are?
Yes, my name's Philip Weber. I'm the regional manager.
You're
Just
still
so-
under oath, Mr. Weber, remind you, you've been
Yes.
previously sworn.
Yes. Just so you understand, these are not Copart employees. They're not Copart vendors. They're not Copart contracted. They're not connected to Copart other than they are buyers. And they're not always the buyers. They're their transporters. So we don't have any control that we can recommend to them. But once they leave our gates, we don't have any control. We don't have control over those people. We can put signage up and instruct them. We'll gladly do that to instruct them not to go across the street or stop. We don't want that to happen as well. So I just wanted to make that clear.
But maybe for my own edification, I apologize. If an individual is leaving your premises and is carrying a load that they are clearly incapable of handling, how is that not your responsibility?
I don't quite follow you.
Mr. Sopko indicated that he has had tow truck drivers who have literally wanted to leave and have left cars in his driveway because they have left your client's property with too many cars that they can't handle.
Okay, they have not left any on my property.
They have asked to
They
leave.
have asked, and they have left on Lexington Street.
Right, and when we load the vehicles, we don't overload them. We load them to what the vehicles the trucks are capable of hauling. So we don't improperly load them. So what they decide to do with those vehicles once they leave, I have no idea.
You got to understand that these cars are in accidents. They've been previously wrecked, and we get all kinds of people trying to think they're getting a really good deal because it doesn't look very damaged, and they have a dealer plate, and they say, "Well, where are you taking this car?" "Well, I'm driving it to Texas." And I'm like, "Good luck, because you're never going to get there probably." I mean, and that's what probably our neighbor's talking about is these people that get over their heads, and all of a sudden they get right down the road, the car breaks down. And that stuff happens all the time. These cars are not roadworthy cars, and people still insist that they can drive them.
Well, I don't think were you saying it was someone who was driving a car and left it? Or are they saying that there was a truck operator, the car was on a truck and they want to get it off the truck and leave it?
There was a truck operator this past Monday.
Okay.
He said he had a 2-car carrier and he had to pick up 5 cars. It was 4:45. He wanted to know if he could leave some of the cars on my property and come back for them later.
So he's trying to get all of the car out of
Right.
Skirting around the 5 o'clock.
So yeah, he's trying to get by without paying storage for the next day, because we charge storage if the car's still there.
But the point is, how, and again, how does an individual go on your lot, take 5 cars off the lot?
With a 2-car carrier.
Thank you.
No, he's not. He wants to unload them and go back and get another.
There you go. Shouldn't that be suspicious? That he takes 2 off the lot and a few minutes later he comes back empty and says, oh, I could take 2 more?
He was trying to do it anyway.
Or at least he was trying to do it. Well, if he never got to do it, then the manager here would never have known that that's what he wanted to do. It's that point as well.
We get a lot of customers that go directly to Klein's with these cars. So it's possible that they picked up 2 cars and they come back immediately because they just dropped them off.
You did tell him no, right?
Oh, yes.
Okay.
Well,
no.
So that's within your purview anyway. Okay. But I guess the distinction here is those who were coming in to drop off cars are contracted to them. Those who are taking them away have no relationship to them.
Okay.
Yeah.
All right. Thank you very much.
Sure. Thank you.
Welcome.
Thank you. Okay. This side of the room. Anybody else? I'll call you, but anybody else before we do? No? Okay.
Do I have to give my name again?
Yes, please.
Maria Janusik, 2155 Camp Lane Road. Just for clarification, I want to know that I understand what was said regarding ordinance 2010-31, amending of the zone of Block 65, Lot 21. This was recorded with the Somerset County Planning Board. Was this recorded with the Somerset County Planning Board?
With the
And does it
Somerset,
have a date of filing?
the Somerset County Clerk, I think it's
Planning Board.
Clerk.
Clerk.
Planning board.
Because it's an amendment to a zoning ordinance, it needs to be sent to the
And the answer is, Mrs. Janusik, we have no idea, one way or the other.
Nobody knows.
Board's not aware of. It's not an item before the board.
And that's not something that needs to be checked, that this property that's being used for an industrial purpose is definitely zoned for an industrial purpose?
If the indication is that the failure to file it with the Somerset County Planning Board 4 years ago renders the property invalid 4 years later, I would indicate that the time frame for doing so has come and gone, but if the board would like to condition the application on confirmation of filing with the county planning board, that's up to the board. But there's no requirement to do so.
Okay.
Okay. My second question, when I had gone to the Hillsborough Planning Department, I was given a copy of the amended site plan for Block 73.01, Lot 1, which is part of the application 14PB15SR, but I didn't get a copy of the amended site plan for Block 71, Lot 1.01. Is there a copy available in the Planning Department? Or is there one? Actually, since this is for both properties, there should be one here.
Are we doing site plan?
I can answer that. There is no, these are two separate lots. We are not amending the site plan on the second lot. We're only amending the conditions of the approval. The site plan amendment is limited to the plan that she has a copy of.
So would this indicate that there is a second lot, or this is, because this looks like the application for only this property?
The application indicates it's for both lots, and it indicates that the site plan amendment is limited to that lot.
The application does?
Yes.
The
Yes.
application states that this site plan is limited. The application states that this site plan is limited to this lot. That's on the application.
Yes, we're not seeking to amend the site plan for the other lot.
Okay. All right. Next item, Block 73.01, Lot 1, according to the record I got from the tax assessor's office, shows that it was built in 1940. It was Vinnie's Auto Salvage. 1940 predated Hillsborough zoning ordinance. So this would be a non-conforming property. This is a non-conforming property. So a non-conforming property cannot increase in size. So I'd like to find out how lots were merged to this and how this changed from 8.1633 acres to 15 point, what is shown on the application, acres.
1940.
Yeah. Mr. Bernstein?
I have to give you credit, Mr. Janasek, because you asked everybody to answer a question of which the only person who seemingly has this information is you. Asking the board whether or not this is now a non-conforming use because it was zoned in a different manner 75 years ago and therefore cannot expand its non-conforming use is not necessarily applicable to the application here. But more importantly, there's nothing before the board. And let me make the following point. This is the fourth hearing. And I have sat here for 4 hearings and listening to you accuse my client of all sorts of improprieties.
I'm sorry, who is your client?
The board.
Okay. I want clarification on that, yes.
There's no dispute with my
But
client.
also,
Mrs. Janasek, can I, Mrs.
I
Janas-
am
No.
your client
No,
because I'm a property owner,
Mrs. Janas-
taxpayer.
Mrs. Janasek,
Yes.
let me break some very bad news to you. I am hired by and retained by the planning board of the Township of Hillsborough to represent and give advice to the Township of Hillsborough Planning Board.
Yes.
Not the residents of the Township of Hillsborough, but those individuals who have been appointed by the Township Committee to serve as planning board members. The mere fact that your taxes help to pay indirectly some of my fees does not make me your attorney, any more than if I was the township attorney. The same situation applies. So if you'd allow me to finish, I would appreciate it. You have come up here multiple times over 4 hearings and continuously raised issues at each and every hearing, requiring board professionals to go back and check them out. And it appears what you're seemingly engaged in is a very, I won't even say sophisticated, is a game of chicken. Because every time you've come up here and raised another issue, my office, Mr. Rydell's office, Mr. White's office has had to go checking. And apparently you've been in possession of information for a period of time and now expect everybody to answer it when you stand up there and accuse this board of not providing you with all the information. So, in reality, you're engaged in the same attributes that you're accusing the board of engaging in, which is giving you selective information, just like you give us selective information. While you're up here, for the last time, what other issues have you been saving till tonight that you've had in your possession before tonight that you now want the board professionals to consider before the board takes an action? Because you know exactly what you're attempting to do. You're attempting to postpone the decision by continuously raising issues that can't be answered on the fly. So what else, for the record, ma'am, last time, are you now going to contend, other than the non-conforming zoning?
You're saying that I'm playing a game of chicken.
I'm asking
And I'm
you-
not asking, and I'm not.
No, I'm asking, I asked,
Excuse me, I listened to you. Please, listen to me.
and I asked you a question which you, as usual, are not answering.
I will
What-
answer it.
Okay.
However, you're accusing me of something, and I want to answer that. At the June 2013 meeting, I asked, how did Block 73.01, Lot 1, come up with 15.68 something acres when something different was shown on the property record card? I was told things were merged, well, all kinds of stuff. I was not given an answer. I got a
weren't- no,
map,
you weren't-
I received a map from Mr. Coyce. I said, this is what I got. Oh, that's the wrong stuff. You don't have the right thing. No one gave me that information. I've been requesting it since 2013.
Mrs. Janasek, first of all, the application doesn't date back to 2013. Secondly, an equal...
I'm talking about the public meeting that I was at in 2013.
And when you raised the issue, you were told it didn't match up with the property record card. How does the not matching up with the property record card devolve to, at 9 o'clock tonight on the 15th of January of 2015, a contention that the property in and of itself is non-conforming?
I would refer you to the meeting of June of 2013 when I asked all these questions. When was the zone changed? Who was notified of the zone? How were lots merged with this? Those were all questions that I asked, and I got
Mrs. Janasek, that has nothing to do with the allegation you're now making. Because whether the lots were merged or not merged, whether the ordinance was or was not adopted at the time, you're alleging, I believe, stop me if I'm wrong here, that back in 1940 this was an auto salvage lot, which predates the township zoning, and therefore Copart is engaging in an expansion of a pre-existing non-conforming use.
Yeah, that's what I'm saying.
Okay. What does that have to do with the discussions you just had about the merging of lots, the zoning?
Because when I
No,
when I asked how that lot became enlarged, I was told lots were merged. So then I asked which lots were merged. At the last meeting in December, I asked that question, and on that question, the meeting was stopped. So I'm not getting answers.
And whether the lots were merged or not merged still doesn't address the issue. So let me ask one last time, for the record, other than the contention that the applicant is engaging in an expansion of a pre-existing non-conforming use, what other allegations are you making relative to this application that the board professionals may or may not have to advise their client regarding taking action on this application? Last chance.
Okay. I had asked from the custodian of records.
I'm not, no,
Zoning is a function of the township. The township changes zones. So
Mhm.
this information would be in the township. So I asked for the ordinance that rezoned Block 73.01, Lot 1, and the answer that I received from the custodian of records, Pamela Borek, was Ordinance 2010-26, which is the adding a new definition for the Internet Vehicle Processing Facility. That doesn't say anything about amending the zone of Block 73.01, Lot 1. Yet in the record, in the minutes, it says
Yes,
this
it
lot was
does.
rezoned.
It amends the zone, which that lot is in, the I-1 zone, by adding a conditional use.
It says
So that is an
nothing- it
amendment of
says
the zone, so
nothing
you're wrong
about-
again.
It says nothing about blocks.
And we've been through this
And
like
we've
the
been
third
through it.
time.
The lot's in the zone.
The amendment for Block 65, Lot 21, specifically states that block and zone, that block and lot is being amended.
That's correct,
This
because,
does not say anything.
Mrs. Janasek,
property refers to.
therein lies, folks, therein lies the failure to understand land use law. The reason why there was a specific ordinance relative to Block 65, Lot 21, was the correction of the zoning to reflect what should have been the appropriate zoning. The ordinance you just cited discusses the amendment to the entire zoning wherever there is an I designation within the township. One of the items allowed is a conditional use allowing for internet carriers. That does not require specific block and lots be mentioned as to that zoning. It merely indicates that everywhere where there is an I zone, in Hillsborough Township, a conditional use of X is now permitted if the ordinance is adopted, which it was.
Okay, so when Hillsborough adopted its zoning ordinance in 1946, according to records I had gotten from Mr. Coyce, most of it was zoned residential. So at some point, this block and lot was changed to I-1. Hillsborough, since it does the zoning, should have that ordinance. So that's another
No, I think you asked.
record I'm requesting.
This is not, you are now requesting that the township research every ordinance
No, just for that area,
when it became an I zone?
yes.
Okay.
Because that's a residential.
Well, that's a public records request. That's not for us to
the
fulfill here
property-
tonight.
But that is a part of the record of the property before this board. Now, Mr. Sopko's property is residential, right across the street. The Manville properties are right on the border, residential. As a matter of fact, there's a cinder block wall with a 7,000-volt electrified fence running across that. So the people who live there live like prisoners with a 7,000-volt fence.
and
That's a
also
residential
irrelevant to
property.
this application.
That's a residential property. It's all residential.
And
How is this?
and the fact is that a municipality, in accordance with its master plan, has the right to zone property literally contiguous to another zone differently than the zone of the property contiguous to it.
I
So the
understand, I read that. Now, you should have some kind of buffer, a buffer between those properties.
Mrs. Janasek, and I'm waiting because I'm going to hear screaming in a minute in my left ear.
Okay, no,
The fact that, no,
when this was zoned I-1, that's it.
let me finish.
That's it.
Let me finish. There is no requirement for a buffer. There is no requirement for designations. There is no requirement for anything other than sound planning consideration when the master plan is adopted and to the extent ordinances are required. You're asking for what, ma'am?
In the Hillsborough Code, it tells you that you need to have buffers between these things.
Buffers between.
If you have a residential zone, you can't have,
The Hills,
that's why people have dust problems.
Ma'am, the Hillsborough Township Code specifically says there must be a buffer between Zone A and Zone B. Does it say that in the Hillsborough Township Code, and if so, what section? You just stated for the record the Hillsborough Township Code requires buffers. I want you to define buffers for this application.
For this application.
Your comment is, I assume that there needs to be.
This application has a lot of non-conforming conditions that can't be changed.
That there needs to be a buffer between the residential zone and the industrial zone. Where in the Hillsborough Township Code does it say there has to be a buffer?
I didn't say between the zones. I'm saying when you've got a residence or, here, hold on.
I apologize to the board, but I have a feeling we're going to need this record at some point.
Does the board have to sit through this crap?
Unfortunately, yes.
I'm sorry, what?
Does the board have to sit through this crap?
If I have to sit through your crap, then you sit through my crap.
We've been here for more than 14
If I have to
hours.
sit through your crap for hours listening, should we make a right-hand turn or a left-hand turn? Should we put some water on the dust? And poor people come here and are saying they've got dust problems.
Is to try to convince this board
they've got
to
traffic
vote your
problems,
way.
and you're going to say
doing nothing
crap,
that way at all.
And you're going to say crap?
I've been here 14 hours listening to
Too
you.
bad. You get paid for this? Do you
No,
get paid for
I
this?
don't.
Then why are you here?
You know, there's 10 of
Then
us
why
here
are
that don't
you
get paid
here?
at all.
Ain't nobody.
You're driving us
ain't
crazy.
Nobody forcing you to be here. I'm here because I'm defending my property. You don't have to be here, and don't call my stuff
Actually,
crap.
we
'cause
do
that's,
have to be
That's
here.
disgusting. That's disgusting. I would not do that to any of you.
Don't talk to someone like this. Just stop, okay? Look, Eric, we're not getting anywhere. The fact is that then you put it in an open, then put it in a direct and clear open public records request, which this board does not fulfill.
This property is before this board. This property is before this board, stating that it is an I-1 light industrial zone. Therefore, I am requesting that record because it affects my property. And so, and this is their property. They should have that record.
And
That's what I'm requesting.
Mrs. Janasek, I will quote the chair. If you want information regarding the designation of this property in the I-1 zone, make that, don't nod your head no. Make the specific request to the custodian of records, and she will provide you what records, if any, exist regarding
No.
such. It is not
No,
the app.
no, no, I don't want to play these games, because I already requested it,
Mr.
and I
Chairman,
was given, and
now
I was
we're out-
given the
now we're out of
internet
order.
vehicle
Now we're out of
processing
order?
facility.
Okay,
I'm
if you
requesting
don't
that.
sit down, I'll have you removed. You're done.
Fine, I want that record.
You're done. Motion to finally close public hearing.
So moved.
Second. All in favor, say aye. Very good. Okay, now, for to be voting on the application, you don't have to repeat everything. Mr. Bernstein before summarized.
Mr. Chairman, I think the board does have to make a preliminary decision.
What's that? Oh, okay.
And that preliminary decision relates to the hours of operation.
Okay.
The app? Somebody's phone is going, that's what I'm
Somebody's
hearing.
phone's going. Okay, go ahead, just continue.
The applicant is requesting an expansion of the hours in two forms.
Yes.
One relates to Saturday hours that don't exist at this time, and the other is Sunday under conditions.
Right.
I think the board, before it votes up or down on the application itself, should decide whether or not, when it votes up or down, whether or not either or both of those conditions are going to be agreeable, going to be part of the resolution.
Vote, or just talk about
I think a discussion for the purposes
Discussion,
of how
okay.
you're going to want the,
So,
assuming
the
you
two
adopt.
things were, if I have it correctly, regular operation, routine operation, Saturday 8 a.m. to 3 p.m., correct?
That's correct.
And that would mean dropping off and picking up vehicles?
Dropping off and picking up vehicles, but with the buffer air, with no machinery operating in the buffer area.
Right, but no,
Saturdays.
no machinery in what you've established as the sort of the special 400-foot buffer?
Right, right.
Okay, so it's regular operations, but no machinery in the buffer area. Okay. Sunday operations, interestingly, 8 to 5, not 8 to 3.
Sunday 8 to 5, allowing full operations following a declared emergency anywhere in the state of New Jersey, provided that prior to a Sunday opening, incoming assignments, i.e. drop-offs, have exceeded 120 damaged vehicles per day for 5 consecutive days, and no more than 4 consecutive Sundays.
Okay. Does this also involve no machinery in the buffer?
We haven't discussed that. I think the purpose of this is to be able to deal with an emergency. I don't know whether or not that's practical.
No, we would need full operation.
Now, therefore, what you're also asking is that Saturday gets converted too, are you not? I mean, would you be saying that, oh, you would operate in full Sunday, but Saturday you'd continue to be 8 to 3 and have no machinery in the buffer during the same emergency?
We didn't address that. Let me explain to my client what you're asking.
Okay. Good.
You okay? You need a break? Why don't we take 5-minute break?
Yes, 5-minute break.
Thank you for your question.
Wait. Yes? Are we back?
Yes.
Okay, we are back, yes.
Thank you for your question, because it's something we actually hadn't considered, and it's very helpful. What we would propose is that in the event of an emergency, in addition to the Sunday operation that we indicated, Saturday would be extended to 5 p.m. and the no operation in the buffer would be in effect on both days, on both Saturday and Sunday. So we hope that's acceptable.
Okay, no, what we need is the clarify. It was a incongruity, so that clears up the incongruity.
Yeah, thank you.
Okay. Is that what you thought we had to?
Among other things.
Yeah, okay. Do you think there's any other incongruities
I don't believe there's any
Okay.
more incongruities than we've already
Okay,
identified.
all right, no, in between different requests, right, and mitigations. Gotcha.
Well, actually, there may be one more,
Okay, all right,
now that I think about it.
okay.
Mr. Liebling, is your client asking for operations during state of emergency for drop-off
A, on Saturday and Sunday after 5 o'clock, and B, for drop-off during Monday through Friday between 5 and 11 o'clock in excess of the number you've established.
That's not on the record right now. That would be a new request if you say yes.
As far as past 5 p.m. on Saturday and Sunday, we did not request that. I don't know if that's something that.
Which, by the way, would require, I believe, an amendment to the application.
Yeah, it would.
And as far as beyond the numbers, we didn't request that either. You're correct. And I don't know if.
Just say no.
Okay, no, we're not asking for that.
Thank you.
Thank you.
That had to be a good answer.
Okay. All right, so I think then now we've resolved that and we have all of the potential,
Right.
both the requests and the mitigations listed as you listed them, plus our discussions.
Along with all the other
right
agreements that the applicant has made on the record and concurred with the various board professionals.
Got it. So for that, we would need a motion, a second, and a vote.
Well, actually, I go back to my earlier comment.
Which is?
The board, I think, before it makes
Okay.
its motion to either approve or to approve this application, I think the question is, are you approving all of it, some of it, or none of it? I.e., the hours of operation on the weekends. Because for all intents and purposes, and Mr. Liebling can correct me if I'm wrong, most of the rest of the application is an amendment to the existing conditions that are going on the property. We are currently operating between 8 a.m. and 5 p.m. Monday to Friday. You are currently engaged in drop-off between 5 p.m. and 11 p.m. Monday to Friday. And
That is basically the guts of the application, is the weekend out. So
The Saturdays and the state of emergencies. That is
the
focus of the application
without
itself.
That, there's really not other.
The rest of it is mitigation.
Right. Exactly. We're not asking to extend anything during the week.
Right. So really, I mean, unless anybody on the board wants to say something about what has been requested, now that that's been clarified, I mean, people can comment on what they think of what has been requested, I'm sure. But I think in the end, it's one vote.
that may be the case.
Yeah. So are there any, and I would ask the board for any last comments or concerns or questions for the applicant? No? I think the board's ready to vote on it before them, having all been clarified now.
The motion is to adopt.
Motion to adopt as per all the criteria.
Conditions, agreements, statements, affirmations on the record through the application.
You agree to that, Mr. Bichette?
Yes.
Okay. Is there a second to that?
I'll second that.
Okay. Roll call, please.
Robert Wagner,
Yes.
Ned Julian,
Neil Julian?
Neil.
Yes.
It's getting late. Dr. Daniel Maroli.
Yeah, well, I'd just like to say with voting with some reservation that, and I've been vocal about my concerns for the residents and their concerns about the history of compliance and my concern about the need for residents to be involved and our police to be involved with controlling everything. With those reservations, hopefully you will abide by everything the way you said that you're going to. Otherwise, this has been a difficult and possibly wasted time if you don't follow through with what you've promised. And so I'll vote yes.
Michael Merdinger.
I agree with Dr. Dan, and I want you to be a good neighbor and compliant with our regulations and a partner with the township. So it's yes.
Robert Eason,
Yes.
John Lapani,
Actually, Mr. Peason and Mr. Lapani cannot vote since we have not, actually, Mr. Peason can vote, Mr. Lapani cannot, because that we are only one short member.
Right.
Who's short?
Mr. Connard.
Vice Chair Steve Cohn,
Actually, Mr. Peason, you have to call his name.
Call Mr. Peason's name, but we strike Mr. Lapani's, because he's alternate too.
Yes.
Vice Chair Steve Cohn,
I vote no. And do I have to cite anything, or
No.
do I just say no?
No, just vote.
I vote no.
Committeeman Frank Delcourt,
I think I made my points earlier. I don't like putting this level of scrutiny on, but I think it's the only way right now that we can have the business operate in a way that I think is consistent with what we're trying to do in that area, and give some relief to some of the neighbors that have had issues. So I can't say I'm optimistic that we'll be successful here, but I'm certainly hopeful, and I hope you will take these comments to heart, because they are this was not a process that I'd like to go through again. So reluctantly, yes.
Deputy Mayor Greg Burchett,
Yes.
Chairman Dr. Stevens Cerise.
Yes.
Mr. Chairman, before, let the record reflect the following so that everybody is on the record. The conditions regarding the change in hours of operation not only have a time frame, but they are conditioned upon the adoption of the approval resolution. Mr. Liebling, I believe, has been here before. His clients may not. There is a process we engage relative to the drafting of the resolution, off the transcripts, a review by staff, reviewed by Mr. Liebling before the board adopts. So we are desperately hoping that we will not be getting a phone call tomorrow from Mr. Stopko, et cetera, saying to us, oh, by the way, we found neighbors out from 8 to 5 on Saturday. That's item number one. Those items that are currently correctable under either existing township ordinance or your existing operations need to be corrected now and not wait for the 30 and 90-day provisions of the conditions of this ordinance, i.e. no parking on Camplain Road. So, thank you, Mr. Chairman.
Okay. Thank you.
Thank you
Counsel.
all. Thanks very much. Very, very productive. Thank you.
There's just one item, scheduling item before the board, yes? Bruce?
There are two meetings coming up next. Would be the business meeting, followed by a regular meeting in February. If it is the board's pleasure, we do have business to conduct for the latter part of this month. It would be January 22nd. I would ask that that meeting be convened. And if it is the chair's pleasure, with the acclamation of the board, the meeting on February 5 may be canceled if you wish, since there's no
because there's nothing on the agenda right now.
Correct.
Okay, so just a notice, we'll be back here for a business meeting next week, third Monday?
22nd.
Third Thursday? Yeah. That is the fourth Thursday. Oh, that's right, New Year's, the first, of course. Fourth Thursday, which is the 22nd. And we need a motion to cancel the February 5th regular meeting, there being no business on the agenda.
So move to cancel the February 5th meeting.
Second.
All in favor, say aye.
Aye.
Any opposed? Okay, it's canceled. Huh? Okay. Okay. That's, okay, fine.
Somebody else will.
Okay, thank you. Motion to adjourn.
So moved.
Second.
All in favor, say aye. Aye. We are adjourned.